Before thinking about what a financial settlement might look like, you need to make sure that you have a clear understanding of your own finances and your spouse's finances. You can't negotiate well unless you have a full picture. Both spouses are required to be transparent and provide full and frank financial disclosure. You should not be reticent to share your financial situation with your partner or to ask them for their financial information. If you are having problems finding out what there is, you should seek legal advice. Once you have all the financial information, there's a checklist of issues that you should consider. This checklist underpins the principles of any settlement. It's found in Section 25 of the Matrimonial Causes Act. The first consideration must be given to the welfare of any children under the age of 18. Other factors for consideration include the ages of the parties, their health, the length of their marriage, and their financial needs and responsibilities. It also includes what each party has brought to the relationship in terms of contributions, the conduct of each party, although this is only relevant in a handful of cases, and any other relevant circumstances, which can include, if they entered into one, a pre- or post-nuptial agreement. Your solicitor can help you consider what the key issues are in your particular circumstances. These might be your housing needs, income needs, and the sharing principle. In more complex cases, these could be the treatment of certain classes of assets, such as business assets or property owned prior to the marriage, third-party claims or trust interests. Early legal advice can help you feel confident in your negotiations, as it will give you clear parameters for what is reasonable, guide you in formulating a strategy, and help you identify what the key issues are. You should also consider other forms of support. In mediation, an impartial mediator helps you and your spouse to reach your own decisions in a confidential setting in which any dependent children are always put first. Mediation is an entirely voluntary process, and both spouses must agree to attend. Exploring mediation is increasingly being encouraged by the court. If mediation is not for you, then collaborative law is another option. In collaborative cases, both parties' solicitors sign an agreement not to issue court proceedings, and all negotiations and decisions take place in four-way meetings, in which a satisfactory outcome is sought for all. The relatively new One Couple, One Lawyer initiative allows both parties to instruct the same solicitor, providing that there's no conflict in what the parties are aiming to achieve. Other popular ways to facilitate negotiation include early neutral evaluation or private FDRs. These are both similar to the financial dispute resolution hearing that would take place in court proceedings, but without the need to go to court. The parties and their legal representatives would choose a qualified person, usually a barrister or solicitor, to act as their judge and give them an objective view as to how a court would likely decide their case. The parties then use this view to negotiate their own settlement. Sometimes, however, court is unavoidable. The main steps in resolving a case through the courts start with issuing the application and receiving a timetable under which you need to exchange financial information. A first directions appointment or FDA hearing is used to consider what further information the court will need to decide the case. It considers any applications for expert evidence. This may be from chartered surveyors if property values are in dispute, accountants to value business interest, or actuaries to review pensions and calculate potential pension shares. It also reviews each party's questionnaire seeking further information from the other party in respect of their financial situation. On occasion, if there's a large measure of agreement between the parties, this hearing can be dispensed with and the case will be listed straight to FDR. An FDR, or Financial Dispute Resolution hearing, is an opportunity to share confidential offers, known as without prejudice offers, with a judge, and for legal representatives to test out their arguments in favour of the position their client is adopting in the negotiations. The judge will give an indication as to what they anticipate the outcome at final hearing would be, and seek to encourage the parties to negotiate an agreement using that steer. That judge would not then be allowed to hear the case at final hearing. If the FDR is unsuccessful, a final hearing is listed. Prior to this, the parties are each required to prepare witness statements containing evidence of the case they're putting forward. This will be their best case and will not necessarily include compromises offered at the FDR hearing. The parties can still continue to negotiate, and some reach an agreement even on the day of the final hearing. Failing this, the judge decides the case. More information on all these options for settlement is found on our website, www.waitmans.com. It's vital to get your agreement incorporated into a court order, as it's the only way to protect yourself against future claims from your ex-spouse. Without a court order, any agreement you've reached isn't binding and your financial claims against each other are still open. There are also some aspects of a financial agreement that cannot take effect unless they're included within an order. For example, a pension provider won't share a pension without a court order. Equally, if for any reason your spouse doesn't honour the agreement you've reached, you'll need to enforce it. And again, this requires the agreement to be incorporated into a court order and recorded in such a way that one of the court's methods of enforcement will work. A solicitor will be able to help you prepare the documents you need to send to the court so that a judge can consider and approve your draft order. It'll then be legally binding.